ladies and gentlemen, we are ready to start this panel number 3 on rule of law, energy transition, and climate. My name is Kari Kuusiniemi. I have the honor to chair this panel. I'm president of the Supreme Administrative Court, previously judge at the court, and prior to that, I was professor of environmental law. Now, I also have the honor to be one of the trustees of the board of the World Law Foundation, which I'm very proud of, even though I didn't say it when I was awarded the medal today. So I hope everyone understands that too. And I would also like to add, given the very, very impressive CVs of the panelists, that I'm holding the presidency of ACA Europe, which is the association of supreme administrative jurisdictions of EU countries. But that's for that. And now I'll be introducing our distinguished speakers. Then later, in one by one, when they take a floor. But already at this stage, I can assure that we have a panel with high-level expertise, and I'm really excited to listen to their remarks. Do you know why the 4th of July this year remains in history? No, it's not because of the US Independence Day, the 247th anniversary of US independence. No, it was the day because it was globally the warmest day ever. Ever means in 120,000 years. Average temperature on Earth was 17.18 degrees centigrade. As we all know, climate change is an existential issue of our time. It's truly global in scope. And that's why it's very important that also this panel reflects participation from different countries, different continents. And climate change is not something we are just preventing or fearing or waiting. It's here. Look at the news reports of the IPCC. It's really devastating. All the scientists, almost all, are unanimous that we are going towards a very severe climate problems. And you can see it in the frequent news on media. Most recently, for example, we have witnessed forest fires in Canada and terrible floods in South Korea, just to mention a few. And unfortunately, I can tell you that we are not on a path consistent with the goals of Paris Agreement. And as we have the honor to visit the headquarters of the UN tomorrow, it may be proper to paraphrase Secretary General Antonio Guterres. We are going to hell. Participants of this conference may be in the first class, most of the world in the economy. Unfortunately, climate change cannot be prevented, but it's not a black and white issue. And every effort to mitigate it and to adapt ourselves to it and to prevent the rise of the temperature, every 10th of degree matters, even if the 1.5 degree milestone would be surpassed. And it's up to us to make the decisions. Energy sector is, of course, a key emitter of greenhouse gases, and energy transition from fossil fuels to renewables is of course, of utmost importance in mitigating climate change. Russia's unprovoked war in Ukraine, where energy is used as a weapon, paradoxically, is also promoting and accelerating energy transition. Political decision makers are responsible for taking measures to tackle climate change. We have multinational agreements, just like Paris Agreement just mentioned, but their effective implementation and enforcement are dearly needed. And here we occur the situation that the courts, as a counterweight of political decision makers, have a critical role in upholding the rule of law. Judges and courts are controlling the legality of political decision making, but also safeguarding fundamental rights and human rights of present and future generations. And it's this crossroads in the Montesquieuan tripartition of state powers, legislative, executive, and jurisdiction. They have all their own roles. Politicians, parliaments, governments have the main role to make legislation as to tackle climate change, for example. But in ultima analysis, it's the courts who bear the responsibility if the politicians are not doing what they should do to tackle climate change. All of our distinguished speakers today have a degree in law. However, in this panel, they have different roles. It's the narrative of the panel that one speaker starts from politics. You may well guess who it's going to be. And then we'll be moving to issues linked to energy transition and private enterprises with 3 speakers. One representing renewable energy producer, one financing of energy transitions, and one arbitration in the field of energy production. And finally, we move to the issues of the rule of law with 3 speakers. The first one is going to address Paris Agreement and human rights. The next, climate litigation and government responsibility. And last but not least, constitutional issues, including separation of powers and the rule of law. Unfortunately, I just learned that the last speaker, President Lavrysen, who is now in Belgium in the festivities of the National Day, he has pre-recorded his presentation.
Thank you, Mr. Chair, for your kind introduction and for the invitation to speak to this panel. I regret that I cannot be with you in person due to our National Day tomorrow, that I shall attend in person because of my function. My presentation is about climate change, law and constitutional issues, the separation of powers and the rule of law. Climate policies and laws have from time to time a huge impact on producers or consumers. Therefore, it's not surprising that those affected by those policies are also from time to time complaining that their constitutional rights are violated, be it the freedom of enterprise, the protection of property, equality before the law, and non-discrimination, or basic principles as legal certainty, legality, and proportionality of criminal offenses and penalties, and so on. The case law of my court may illustrate this. We have judged over time around 15 cases dealing with climate change legislation. And I will give you some examples. So the court found in a judgment of 7th of June 2006, dealing with the emission trading scheme, no discrimination of steel companies compared with the non-ferrous and the chemical industries, which were not subjected at the time at the emission trading scheme. The court ruled that in the first commitment period of the European Union scheme, it was justified to start applying the system to the largest emitters first. Climate change policies justify limitations on freedom of enterprise and property rights. The court held in another judgment of December 2006 that the development of offshore wind energy justifies higher government support than land-based wind farming because of the extra cost of this type of renewable electricity production. After the court has referred the case for a preliminary ruling to the Court of Justice of the European Union, it held in a judgment of December 2010 that the obligation to blend a growing percentage of biofuels into fuels for cars entailed no violation of the freedom of religion, various European Union directives, the freedom of enterprise, nor of the free movement of goods. In two judgments of last year and this year, the court held that the restriction on property rights and the freedom of enterprise due to regional legislation phasing out fossil heating was justified and proportionate in the light of the greenhouse gas reduction targets under the Paris Agreement and the European Union burden sharing regulation. Climate litigation, and in particular strategic climate litigation, in which citizens and NGOs are requesting for more ambitious climate action, is on the rise worldwide. Often in those cases, an argument of separation of powers is invoked to decline the action. Indeed, the separation of powers is a strong pillar of the rule of law, but its precise understanding varies between various legal systems and jurisdictions. The argument was all the time present in the well-known Urgenda case. The state of the Netherlands argued in first instance, in appeal and in cassation, that it was up to the legislator and the executive to determine how ambitious its climate policy should be, and by accepting the claim and imposing more mitigation efforts from the state of the Netherlands, the judiciary would in fact take the place of the legislator and the executive, and thus violate the fundamental principle of the separation of powers and undermine representative democracy. It was finally up to the Supreme Court to say a last word on this issue. Based on a very detailed conclusion of two advocates general, the court dismissed the cassation appeal in a judgment of December 20th, 2019. The Supreme Court based its judgment on the United Nations Framework Convention on Climate Change and on the state's legal obligation to protect the life and the well-being of civilians in the Netherlands, enshrined in the European Convention of Human Rights. According to the court, there is a broad consensus between science and the international community on the urgent need for developed countries to reduce greenhouse gas emissions by at least 25% towards the end of 2020. The state has not explained why a smaller reduction can be considered justified and may still achieve the ultimate objective accepted by the state of the Netherlands. The state had defended the thesis that decision-making on the reduction of greenhouse gases belongs to policymakers, However, the court observes that the Constitution obliges the Dutch judge to apply the provisions of the European Convention of Human Rights. The judge's task of providing legal protection is an essential element of the democratic rule of law. This is what the Court of Appeal did in this case, according to the Dutch Supreme Court. By imposing a global reduction target without prescribing concrete measures to reach that objective, it is argued that there is no breach of the principle of separation of powers. The legislator and the executive remain competent to work out the concrete policy mix of instruments to reach that goal, enjoying a large margin of appreciation in doing so. The decision in the Urgenda case contrasts with the decision of the Federal Supreme Court of Switzerland in the Klimasignorinen case, in which the court held that deciding on the climate change policy ambition of Switzerland was a matter reserved to the parliament and the government. Germany illustrates that the constitution can also be of great importance from another point of view. In February 2020, a group of young German people filed a legal challenge before the Federal Constitutional Court to Germany's Federal Climate Protection Act, arguing that the target of reducing greenhouse gases with 55% by 2030 from 1990 levels was insufficient. The complainants alleged that the act therefore violated their human rights as protected by the Basic Law, Germany's constitution. On April 29, 2021, the Federal Constitutional Court in the so-called Neubauer et al. Struck down parts of the Climate Act as incompatible with fundamental rights for failing to set sufficient provisions for emissions cuts beyond 2030. The court found that Article 20A of the Federal Constitution obliges the legislature to protect the climate and to aim at achieving climate neutrality. The court stated that Article 20A is a justiciable legal norm that is intended to bind the political process in favor of ecological concerns, also with a view to the future generations that are particularly affected. Accepting arguments that the legislator must follow a carbon budget approach to limit global warming well below 20 degrees Celsius, and if possible to maximum 1.5 degrees Celsius, the court found that the legislator had not proportionally distributed the budget between the current and the future generations, writing, and I quote, "One generation must not be allowed to consume large parts of the carbon dioxide budget under a comparatively mild reduction burden if this would be at the same time leave future generations with a radical reduction burden and expose their lives to serious losses of freedom." The court ordered the legislator to set clear provisions for reduction targets from 2031 onwards by the end of 2022. Following that ruling, and with a view to the new European climate targets for 2030, meanwhile adopted, the German federal government presented an amended Climate Change Act in 2021, which was adopted. Following the reasoning of the German Constitutional Court, and in light of the most UNEP-GAP reports, it might be expected that the constitutional dimension of climate change policy will only be more and more on the forefront in the decades to come. With that, I conclude my presentation, and I thank you for your attention. I wish you further fruitful discussions. Thank you.
So let's start with the Minister Judit Varga from Hungary. She's going to tell us about multinational environmental agreements, state responsibility, and borderlines between policy and the rule of law. Dr. Varga has, since 2018, worked as Minister of State for EU Relations at the Prime Minister's Office and as Minister of Justice since July 2019. After obtaining her law degree, summa cum laude, in 2004, she worked as a trainee associate in law firms. Until 2009, she worked as a trainee judge, passed her bar exam in 2009, and then worked for 9 years as a political advisor to several members of the European Parliament. Regarding her young age, a very impressive CV and a versatile career indeed. Madam Minister, the floor is yours.
Thank you very much, dear Mr. President, distinguished members of the panel. It is my great honor to be here with you. Actually, we are in New York and I'm coming from another continent like you, Mr. President. So it is really a great opportunity to exchange our views from all across the continent. And it's also my pleasure to touch upon those issues which I had been dealing with in the European Parliament as an advisor in the Environment Committee, actually. But being a minister, being an active politician, I would like to put some light on the policy makers' perspective, especially on the energy transition challenges. But before I jump into my speech, which I well crafted in order to remain within the time limit, I would like to congratulate you on your award.
Thank you.
It's a real honor to witness it. And I would like also to say that in a couple of weeks, I'm resigning because I'm looking for new endeavors and I will be heading the national list for the Conservative Party for the European elections for next year. So this is why I will be much more engaged in political party campaigning, and I will be chairing the European Affairs Committee in the Hungarian National Assembly as being an MP also. So dear ladies and gentlemen, let me start by a quotation from a Nobel Prize winner, Paul Crutzen, a meteorologist at the time. He said that it's a pity we are still officially living in an age called the Holocene. The Anthropocene, human dominance of biological, chemical, and geological processes on Earth is already an undeniable reality. So Paul Crutzen described this way the phenomenon that defines the present and future of the relationship between the mankind and our environment. On the one hand, this description is deeply disappointing. It reflects the extent the human behavior is changing, mainly destroying the created world. On the other hand, it reflects hope, especially for us, lawyers. If namely the biological, chemical, and geological processes on Earth are dominated by the man, then the laws of the human society can have a significant impact on these developments. And while defining these answers, particular attention is needed to ensure proper balance between, and now 3 elements are coming, proper balance between our current needs and future welfare, proper balance between specificities of our countries and the need for common action, and third, the legitimate interests of the society and that of the individuals, and the basic safeguards of rule of law, human rights, and democracy. So, honorable colleagues, a vivid example for the complexity of these issues and the burning challenge is related to the Russian aggression in Ukraine and its global effects on energy policy. For those who are not so much acquainted with the borders of Hungary, we are actually a neighboring country to Ukraine, and especially in Transcarpathia, there is 150,000 Hungarian minority living, those Hungarian Ukrainian double citizens who actually are falling in the war. So we are very close to this conflict. It is tangible for us. So the global effect on energy policy of this war, which is due to our special geographic location, is particularly crucial in Hungary. Everybody knows that Brussels, the European Union, imposed sanctions on Russia, but this caused energy prices in Hungary to skyrocket. So there was a constant instant effect of the sanctions on my country. So the most important considerations now for us Hungarians is securing our energy supply and bringing down the sanctions surcharge on energy, because it was not our decision, but after the decisions after the Second World War, there was a new world order created, where, for example, all the logistical and infrastructural part was actually linked us basically physically to Russia, because 80% of our households' gas, natural gas supply, comes from Russia. So for us, it's a vital question: what do we do with energy sanctions and decisions? So our aim is to protect people living in Hungary, to support pensioners, families, especially by the caps on household energy bills, and to maintain workplaces. The caps on energy bills means that by law, we are determining the maximum price which an average household may pay for their living. So this is an important measure how to protect our citizens from the effects of the sanctions, for example. That is why we do not support any proposal that directly or indirectly puts our energy security at risk or raises the prices beyond affordable. Therefore, if you hear in certain news, I'm sure you hear certain news that Hungary is criticizing sanctions in the field of energy, or that we are pushing for specific exemptions, like during the case of the oil embargo, please be reminded, a landlocked country with no ports, with poor own energy resources, shall be particularly careful in order to comply both with the need for current energy security and the rights of the future generations. And with the spread of renewable energy sources, especially in Hungary, we have a great potential for renewables, the solar, the photovoltaic. It will be by 2040, 40% of our primary energy production. And with the availability of predictable nuclear energy, we have a very safe and good nuclear energy power plant, which produces actually 1/3 of our energy supply. Hungary is becoming less and less dependent on foreign energy exports, but Russian energy sources still make up a significant part of our energy mix, especially during the heating season. This is a fact, actually, matter of fact. Even if we have diversified links to our neighbors, the source of the neighbor's pipe is also a Russian gas. So this is why it's not easy to just cut ourselves and our industry off from Russian sources. So our efforts shall be interpreted by taking into account that Hungary has set the greenhouse gas emission reduction target of at least 40% by 2030 compared to 1990. And if you remember the Kyoto goals, which was reduction by 20% based on 1990 levels by 2020, Hungary actually overpassed this objective we were 33% reduction, so even 13% more than committed to. Hungary was among the first member states of the European Union that have enshrined national emission reduction targets in law. So the efficiency of our efforts is also demonstrated by the fact that according to the KPMG Net Zero Readiness Index, Hungary is the 13th most prepared state among the countries examined to achieve decarbonization goals. By making our policy decisions in the field of energy transition and climate protection, we also pay particular attention to our national constitutional framework. The fundamental law of Hungary highlights the environmental and cultural values of Hungary and stipulates that it is the obligation of everyone to protect these values for the interest of future generations. As a mother of three and also a conservative politician, I also believe that this an effective climate and green policy is our Christian and conservative patriotic duty to preserve our creative world. So, ladies and gentlemen, my last page is coming. It is undeniable that only multilateral cooperation, and here comes the importance of multilateral cooperation, can safeguard the overall efficiency of national solutions in the fight for preserving our environment. But this cooperation shall be based on a common approach, which is based on the following elements, 3 elements. We shall ensure democratic decision-making. We need to inform our citizens and consult them regularly. Let's ask them the most sensitive questions about also our energy mix, our decisions, how we're gonna meet those common objectives agreed at the international level, because there are specificities at national level, which should be also consulted by the demos. Secondly, mutual trust requires that instead of shifting the cost of protecting our environment to poorer countries or to the most vulnerable citizens, the cost should primarily be borne by large polluting companies or countries. And finally, equality in multilateral cooperation requires that the specific steps of a particular state taken to ensure the well-being and the democratic choices of the citizens should not lead to stigmatization in the international community. On the basis of this principle, we can elaborate proper solutions to uphold our legal values, preserve the interest of our current, future generations, and sustain our environment. Thank you very much for your attention.
Thank you, Madam Minister. It was a very concise presentation.
Thank you.
Yeah.
Yeah,
What-
too much in the panel.
Was I threatening too much in advance?
No.
Yeah, so but this made a very good introduction for the panel, and as agreed from the political decision makers' perspective. And now we are moving to the next part of this panel, and it is started by Mr. Santiago Martínez Garrido. He's General Secretary and Secretary of the Board of Directors of Iberdrola. And Iberdrola is the world-leading company in renewable energy. And his topic is towards the new climate governance. Mr. Martínez, as said, is General Secretary and Secretary of the Board of Directors in that company since beginning of this year. Previously, still he's also a director of two other energy companies, and he has a degree and doctorate in law, and also a business degree. He has held several positions at Iberdrola, including Deputy Secretary of the Board of Directors and Director of Legal Services. He has also worked as a government lawyer at the High Courts of Justice and the Home Office. He's been Chief of Staff of the Secretary of State for Justice and Chief of Staff of the Ministry of Justice. So he has also a very close links to politics and Ministry of Justice. Yeah, please, you have the floor.
Okay, thank you so much, Kari, for your kind introduction. No, it's a pleasure, and as you mentioned previously, I'm going to give our point of view that there's a private company. Iberdrola is a private company from the beginning. We are not in any time a public company, and we have to make a decision regarding the production of the electricity and regarding the situation of the context of the climate change and energy transition. As you mentioned, as the only representative of the business sector, I would like to focus my intervention on what role I think that the companies are called to play in such context for urgent problem that we have at this moment, that is the climate change, the climate action. Indeed, battle for the planet's survival, I believe that everyone is called upon, without a doubt, company and especially utilities have an important role to play, and we should do that immediately. Today, nobody questions that the climate change is one of the biggest challenges that we face. Human activity is impacting and creating radical changes in the environment. But I think that it's not the time for declaration, it's the time for the action that the Secretary of the United Nations mentioned in the last meeting about the transition process. The energy sector is one of the more relevant revolutions to reduce the emission of CO2, but promising further future reduction is very easy. What is difficult is to deliver, no? But we don't need emission reduction commitment now. We need the actual and real reduction emission at this moment. In addition, I think that it has been proved that energy transition is fundamental to exit, as the Minister said, to energy crisis situation and achieve climate goals. The Paris Agreement is a landmark on how we can address global challenges. 70% of the world economy have set a policy to reach net zero greenhouse gas emission by mid-century. Energy climate law have served to introduce restriction or prohibition on legally limited to the greenhouse emission in a specific country or sector in a specific year. But climate energy law also need to be enforceable, which is still well on the pending issue, through it seems to be improving on several court cases, like in the Netherlands, France, and UK, recognize climate damage as a violation of the human rights. But this is not enough. Under actual circumstances, the growing role of the private sector as a global actor, and especially in the energy sector, the climate action became indispensable. It is not the time to hide behind the fact that we are doing what the law requires, but we should go ahead, but we go beyond that law recommends. Also, the law plays an essential role in the regulation of climate objectives and other related aspects. The reality that is necessary to go a step further, and the contribution of the private sector, its commitment and business decision are more than ever key to face the global challenges of climate change. It is not a legal issue, it's an issue of responsibility. Leadership of companies is essential in a situation where they can advance more in the fight against climate change. And in the case of companies like the Iberdrola Group, this step further is even more important and involves going further in the compromise and adopting voluntary commitment as soft law that will shut down the climate change crisis. But companies with commitments are not the same as committed companies. Years ago, corporate social responsibility was limited to a portfolio of philanthropic work performed by business to give back to the community from which they had benefit. It is not related to core operation of the business. The real step forward is with ESG. The time to be responsible is running out, and the time to demand accountability is about or has been to be. It is a way of making business accountable of an internal set of philosophy and also to measure set of impact linked of wide common good. A simply global context where energy transition and decarbonization of the economy is not the challenger of the future, but the challenger of our future if we are not able to decisively address to reduction emission, coupled with the increasing accounting, reporting, and disclosure requirement for clients across every sector requires companies to be ahead of sustainability and ESG integration. And within the ESG business model, I think it's time to focus on the G in two ways: to ensure that commitment of the companies are credible and to regulate how companies can go a step further in the climate action. And the G must be the substrate that allow the credible development of the E and the S. Governance reflects of an organization's internal policies and practice, leadership structure, compliance, and overall decision-making process. Good governance is essential for long-term success. If an organization has a strong governance, it is more likely to make sound decisions, maintain the trust its shareholder, and create value for everybody. And all stakeholders are increasing interest in companies with strong ESG values and practice, including good governance, transparency, and accountability, and appropriate risk management. But the G, or good governance, is also means going a step further. In the energy sector, private financial institutions and investors are increasingly asking their invested companies to demonstrate how their business model are compatible with the energy transition in the light of the increasing demanding standard of ethical behavior and social commitment. They have understood that it's necessary to differentiate between the companies with what are obligated to the rule of law and what constitutes an additional step in our commitment to society in terms of addressing climate change. The whole concept of economic profitability of company is supported by the need to respond not only with an economic dividend, but also with a social dividend of their activity to all the stakeholders, not only the shareholder, to the employees, business partners, and the society as a whole. Effective corporate governance, I think, is essential to ensure that ESG passion translates into concrete action and systematic change. So an adequate and coherent regulation of today's climate governance constitutes an essential aspect of the function of a company. And in Iberdrola, we achieved this goal because we believe in our strategy is development. We are talking about facts, delivered through more than 20 years. In 2022, Iberdrola emission intensity was 3 times lower than the average European electricity company. Thanks because more than 90% of our production are emission-free. In 2022, we are not talking about the future, we are talking about the present. Our strategy is essential to gradually cut back on emission by generating power from renewable sources with the goal of achieving carbon neutrality in 2030, net zero emission before 2040. From the beginning, we believe that having a good corporate governance system was essential for the credibility of the project and for the growth. Today, this is normal. The difficult thing was to do it 20 years ago and to do as a real informed commitment of soft law and not as a mere programmatic statement of aspirational objectives. Iberdrola governance and sustainability system is one of our distinctive features and placed in the forefront of the corporate governance. It is the first company that includes the social commitment in our law. Through corporate policies, is assumed the commitment to sustainability management, environmental policy, and climate action policies. It obligate the board to develop its strategy with absolute respect to the environment and the elimination of the greenhouse gas. But of course, that legislation is dynamic, and that climate change are in constant change. So our corporate governance system is also in constant revision to include best international practice and new commitment. G is a priority within our ESG business model. Let me end by saying that an adequate contribution between rule of law and corporate governance is the best way to fight climate change, as we need companies that develop a real sustainable climate governance. Also, that the G in ESG is crucial when evaluating an organization's impact on the world. Good governance is vital for an organization's long-term success and include risk management, decision-making, transparency, compliance, and ethical behavior. Organizations with a strong governance practice promote sustainable, compliance, and ethical business practice while benefit from increased value and positive financial returns. This promotion of the rule of law must take shape through soft law instruments that allow for a true sustainable climate governance, with utility at the driver of the necessary and essential change to achieve the carbon neutrality. And for this, those who have the capacity to implement it have the great responsibility. Thank you.
Thank you so much, Santiago, for your important intervention. So now we have had the regulators' points of view, and now we heard the company approach. And I would already at this stage pick up that the idea of ESG, environmental social governance, it's vital when the companies are not just obeying the regulation, but they are doing work to invent technology, driving solutions, and so on. So it doesn't help too much, as also pointed out by the minister, what kind of laws and agreements we do have. The implementation and the enforcement is crucial. Thank you once again. And now we move over to our next speaker, Kelly Hewitt, who is Principal Energy Specialist from Asian Development Bank. And she will tell us about energy transition, climate challenges, and alternative collaborative processes. Juris Doctorate lawyer and master degree economist, Kelly Hewitt is Principal Energy Specialist in ADB since 2011. Her primary focus has been non-sovereign and sovereign clean energy sector projects, programs, and sector development strategies. She's currently leading Paris Agreement-aligned clean energy program and project development throughout the Asia and Pacific region. Earlier, she's worked in power and natural gas branch for more than 30 years, believe it or not, with extensive experience in power and gas market regulation and reform, energy efficiency, climate change mitigation, and renewable energy. She also served as legal counsel at U.S. Department of Energy and several positions in private enterprises, including merger and acquisition group and energy law firm. Kelly, please, the floor is yours.
Thank you. Good day to all of you. First, let me clarify, I'm obviously from the United States, not the Philippines. I've been living and working in Asia for nearly 20 years. The last 12 years have been in Manila, Philippines, with the Asian Development Bank. Before I get into my discussion, I want to let you know that the Asian Development Bank, and when it comes to the energy transition, isn't just limited to financing projects per se. Our clients and our partners are Asian Pacific countries, and also regional groups that have formed regional alliances to come up with solutions that are oriented not toward just clean energy, but development in essence. In addition to that, it's important that I explain that the Asian Development Bank isn't just limited to providing grants and loans. We also obviously issue bonds, some of which are green and blue bonds. We also provide guarantees, and some of our clients are also non-sovereign private sector. So I give you that backdrop. In regard to what I'm going to speak about today, I'm focusing on the ways in which we work with our client countries in establishing guidance for policies to move them closer to their Paris Agreement commitments. So it's from a assistance or governance perspective that I'll be focusing. I can't recall a time since the early 1990s when energy, particularly clean energy, was the hot topic of conversation outside of energy companies, outside of administrative adjudicatory forums, and outside of appellate courts. Yet now, clean energy and autonomous energy choice, both supply and demand, has become a universal concern, voiced by all, not limited to a particular segment of society. Energy now is a hot topic, perhaps even the hot topic, because of the energy sector's enormous negative global carbonization impacts on lives throughout the world. Hence, energy law, particularly in the climate change solution context, requires some careful attention to help guide developing Asia and other regions in meeting climate change targets while maintaining constructive, substantive, as well as procedural rule of law. Energy law, particularly that which is necessary for a successful energy transition, has been practiced differently from that of environmental law. Environmental law often surrounds issues of compliance. Indeed, both environmental and energy law are important in addressing climate change and are necessarily coupled to address the world's climate crisis. However, the practice of energy law historically has at its core economics. The rationale of economics at the core of energy law stems from the 1944 US Supreme Court case, Federal Power Commission versus Hope. Now, I won't bore you with the Hope ruling in detail, yet I want to draw your attention to the fact that Hope ruling goes to pricing, and that US Supreme Court ruling has yet to be overturned. Hope calls for regulated power pricing to be just, reasonable, and not unduly discriminatory. In other words, fair. When practiced correctly, with an understanding that rent-seeking interests must be mitigated, economics at the core of energy law enables just energy transitions by binding economic security and inclusive growth, alongside the energy sector in a practical, sustainable way. Energy law, considering developing Asia and Pacific contexts and developing Asia and Pacific countries' energy transition efforts and global climate change challenges, has limited precedent or established jurisprudence outside of basic licensing and rate determinations. When I say this, it's important that I move two outliers, India and China, outside the equation. Their positioning for a successful energy transition is quite different and more established compared to other developing Asia and Pacific countries. Energy transitions are not restricted to matters of compliance, but rather enable pathways for alternative adjudicatory processes that further collaboration, inclusion, and fairness. For a successful energy transition to be had, all stakeholder voices must have the opportunity to be included and considered. Experiences in the US tell us that opportunity for collaborative processes, when seized, often avoids litigation, administrative as well as judicial, while facilitating inclusion, transparency, accountability, and just results in a good governance context. If Asian Pacific countries can adopt non-litigious, formal, collaborative climate energy processes, the region would be well on its way to sustainable, just energy transitions that are entrenched in solid aspects of rule of law that is grounded in openness, transparency, and inclusion. It's important to pause here to point out that the benefits of a just energy transition, if done right from a rule of law perspective, and not limited to country-specific borders, but can indeed facilitate both regional and global solutions to climate changes. What do I mean by this? In developing Asia and Pacific, the Paris Agreement aligned long-term strategies and nationally determined contributions enable prioritization of development infrastructure. Indeed, this is difficult, particularly when countries perceive some conflict between Paris Agreement commitments and economic growth and security. Without deep diving, the aspects of openness, transparency, and inclusion discussed earlier with regard to formal collaborative processes also benefit developing countries in establishing and implementing monitoring, reporting, and verification systems and processes that aim to identify greenhouse gas emission trends and actual decarbonization progress resulting from long-term strategies prioritized infrastructure. Without that clear picture, one doesn't know what's being saved, what decarbonization is taking place, and what's needed to fill any gaps. In conclusion, despite the climate challenges that developing Asia and Pacific countries face, an energy transition that reflects ideal rule of law characteristics of openness, transparency, and inclusion are included in formal collaborative processes that not only demonstrate good governance and democratic principles, yet also enable countries and regions to create Paris Agreement globally agreed upon MRVs, monitoring, reporting, and verification systems for tracking their decarbonization and openly demonstrating their climate action results. For now, I'll pause here. We can have further discussion. Thank you.
Thank you, Kelly. When planning this panel, we were talking about whether you feel to be in the right panel. So I think the audience can now say that, yes, you're in the right panel. Thank you so much. And I found quite interesting links also to Minister Varga's speech. For instance, you mentioned this Supreme Court judgment, Hope, and the fair pricing of energy. So this is very important that also the presentations of the panelists discuss with each other. Thank you.
But I did live in Hungary for 3 years.
Yeah.
So.
Wonderful. So let's move forward. Our next speaker is Sven Volkmer. I hope I pronounced it correctly, because I learned that you're German by birth, even though it's here USA. Just like there's not Philippines in Kelly's title. Sven is going to tell us about investor-state disputes relating to the energy transition. And to introduce him, he's a partner in the White & Case International Arbitration Group in New York. So it's in the home field. He represents companies and states in commercial and investment treaty arbitrations in a range of industries and around the globe, with a focus on the energy sector. He's been counsel in arbitrations under all major institutional rules, as well as ad hoc arbitrations. Sven is trained in common law and civil law jurisdictions, and he's a member of the bar in New York, so really home field, yeah, and Paris also. And his CV includes an impressive list of commercial and investment arbitrations and several publications. Please, the floor is yours.
Thank you, Kari. It's a pleasure to be here. As Kari mentioned, part of my practice is to represent both investors and states in investor-state disputes under so-called international investment treaties. I've had the pleasure of defending Hungary in one of these cases some time ago. And it was successful, yes. Hungary prevailed. And I'd like to talk about that practice today as it relates to the energy transition. The transition involves enormous change, where there's change to their disputes, and where states have an active role in bringing about that change, their disputes with states. The energy transition and investor-state arbitrations in relation to it has gotten a lot of bad press. Investment treaty arbitration has been described as an obstacle to climate change, mitigating measures to the energy transition. And I'll make the case today that that is in large part undeserved. And I'm well aware that I may be the only one on this panel who has that view. But let's see if I can get that point across. So briefly, by way of background, what kinds of investor-state disputes am I referring to when I talk about investment treaty arbitration? Two categories. One would be incentive regimes for renewable energy that countries across the globe have put into effect that try to bring about more investment in renewables. A typical fact pattern is that investors invest under one of these regimes. States then have to make changes to the regime for any number of reasons. The investor says, this disproportionately unfairly hurts my bottom line. I now have a claim against the state for compensation. That's one category of disputes. The other category relates to measures taken by states to reduce fossil fuels, to restrict fossil fuels. One example would be the phase out of coal power in the Netherlands that has given rise to cases under investment treaties. Those tend to be fewer in number, but higher profile, because they seem to be an example of investment arbitration being in the way of bringing about the energy transition. And we'll talk about that a little bit more. Now, that view of investment arbitration being an obstacle has been endorsed by the UN, by the UN's Intergovernmental Panel on Climate Change in a report last year. This is what it says: international investment agreements may lead to regulatory chill, which may lead to countries refraining from or delaying the adoption of mitigation policies, such as phasing out fossil fuels. Now, much of that debate recently has revolved around a treaty that is called the Energy Charter Treaty. It's a multilateral treaty for cooperation in the energy sector, and it includes protections for investments in the energy sector. Now, can it fairly be said that the Energy Charter Treaty, or ECT, is an obstacle to climate change? I propose to look at this, first of all, from sort of a bird's eye view. The Energy Charter Secretariat has reported 158 cases under the treaty since its adoption in the 90s. 2/3 of those cases actually relate to renewable energy. They relate to the types of cases I mentioned earlier: incentive regimes, investors investing, doing, we would say, the right thing by investing in renewable energy, but then encountering problems that lead to claims against states. I would submit that those cases cannot fairly be described as an obstacle to the transition. On the contrary, they're part of the growing pains of the transition. Now, the remaining third of the 158 cases do relate to fossil fuels. Fossil fuel cases have been brought under the ECT, but most of those have nothing to do with the energy transition. They're about such things as taxation. They're about disputes that have arisen long before the transition even started. Now, a handful of cases, ECT cases, do relate to restrictions on fossil fuels. I mentioned the coal phase out of the Netherlands. And I'll look at one of those cases in a little bit more detail, because I think even when you look at the detail, the thesis that it the ECT is an obstacle to the transition doesn't really hold up. So I'll talk about one case involving Italy. Rockhopper v. Italy, recently decided last year. It involved an investment by a UK company in Italy in oil production. The company had gone through a lengthy licensing process that involved several steps of state approvals. All the approvals were obtained, all the conditions were fulfilled to get that license. And at the last moment, Italy changed its law and said, we now ban offshore drilling. We don't want fossil fuel production off the coast of Italy, and the license was never granted. The tribunal found that that was taking away a right that Rockhopper had already obtained. They had gone through all the approvals, including environmental impact studies, and Italy was basically now in a position where they had to grant the license. Now, on the one hand, that can be described as a case where the fossil fuel company wins and it's bad for the transition. But really, the case turns on very specific facts, right? It turns on approvals being given and then taken away in a very short period of time. The case does not stand for a general principle that states cannot restrict fossil fuel production. And I think another thing stands out about the case. The tribunal was painfully aware of the role that it played in the transition and the sovereignty that Italy enjoyed to do what it seemed deemed right with fossil fuels. Now, there's read a short excerpt from the award that I think really gets that point across. So this is the tribunal saying, Italy's decision to ban oil production was a sovereign decision made by Italy. And the tribunal indicates at the very outset that it should not be taken in any way to either criticize or deprecate that decision from either a political or environmental standpoint. Its sovereign choice to prescribe such offshore production based on its own inherent authority and dignity was its to make. Now, I would submit that that is the opposite of a tribunal trying to give a handout to an energy company. This is a tribunal realizing its role in the transition and trying to be mindful of the transition and the role that it plays. Now, one more point that is often overlooked when criticizing these international investment agreements. Investors, of course, enjoy rights under national law as well. And a good example of that is the Vattenfall case in Germany, my home country, some time ago. Germany went through a rapid change in its position on nuclear energy. End of 2010, new government comes in, says we would like to keep nuclear power online for longer than initially planned. A few months later, everybody will remember the Fukushima disaster happened, and the government changed course and said, we're actually now going to take the nuclear plants offline much faster than anticipated. Vattenfall is a Swedish energy company that brought a claim against Germany under the ECT, this Energy Charter Treaty, but it also brought a claim in the Constitutional Court of Germany. And in the Constitutional Court of Germany, the company and others with it prevailed. And the Constitutional Court of Germany said, yes, this rapid change of policy, no matter how well-intended and no matter how reasonable it may be as a matter of policy, hurt the rights of these investors who were told at one point in time, you can keep your plants online for longer, and they made investments based on that promise. And then literally 3 months later, actually, never mind, you have to take them off now. The Constitutional Court of Germany said that this frustrated so-called legitimate expectations that the investors had and awarded compensation. And Germany then settled both the ECT claim and the constitutional law claims with these energy companies. Now, the Constitutional Court of Germany is not a secretive forum that gives handouts to energy companies, which is sort of the criticism that is sometimes levied against arbitration. And yet it arrived at a conclusion that is not too different from one that one might have seen in the ECT case had it gone all the way. So where does that leave us? I would say the criticism of the investment treaty arbitration system is largely undeserved. Tearing the whole system down, as some propose, would be the wrong way to go. It has a role to play, including in protecting investments in renewable energy and related industries that will be so important to drive forward the energy transition. So I would submit the way forward is reform and not tearing the whole thing down.
Thank you so much, Sven. It was really thrilling to listen to your presentation, keeping in mind the discussion we had maybe 5 years ago in Finland concerning these investment protection treaties, and I would say that it was quite a fierce debate in our country. But at the same time, your excellent presentation paved the way, or even constructed a bridge to the next part of this panel, because you tackled the relationships of state regulators and courts and businesses, but from the point of view of arbitration. And now the next speakers are more close to national courts, even though our next speaker is not a judge, but she will tackle very relevant issues concerning international agreements and I think also their interpretation in national and also international courts. So please welcome Professor Christina Voigt from Norway. Dr. Voigt is a professor of law at the University of Oslo. She's an internationally renowned expert in international environmental law and teaches, speaks, and publishes widely on legal issues on climate change, environmental multilateralism, and sustainability. If I'm not mistaken, you just published an article maybe yesterday or so. I read on Twitter. From 2009 to 2018, she worked as principal legal advisor for the government of Norway in the UN climate negotiations and negotiated the Paris Agreement and its rulebook. Professor Voigt is chair of the IUCN World Commission on Environmental Law and co-chair of the Paris Agreement Implementation and Compliance Committee. And her topic is the role of Paris Agreement and human rights law. Please, the floor is yours.
Thank you so much for your kind introduction. And thank you also for inviting me to this very fascinating panel. I've been listening very carefully, and I'm so impressed by the different layers and interlinkages between the presentations of the previous speakers. I would also like to thank you, because I have a feeling that this may be due to your influence, for including such a strong focus on climate change at this Congress. And I'm sure you had a slight say in that. So that's very, very impressive and shows your vision and your foresight. What I will be speaking about fairly briefly is the role of the Paris Agreement in human rights-based climate litigation. And maybe from that topic, you may already perceive that these are two different areas of law, which now come together and are being joined in very interesting, but also very intricate ways. As you perhaps know, we are currently seeing many climate claims at national courts. There's really a groundswell internationally. I don't have to tell the US-based lawyers about that, but we see it in many other countries too. But also at international courts or supranational courts. We have currently a number of claims pending at the European Court on Human Rights, but also several requests for advisory opinions from international courts like the International Court of Justice, the International Tribunal of the Sea, and the Inter-American Court on Human Rights. Just briefly going back to the European Court on Human Rights, the question there is whether individuals in those cases that are pending are violated in their human rights under the European Convention on Human Rights, for example, in their right to life, in their right to private life, and a number of other rights that are included in that convention. Now, the violation of human rights by climate change impacts itself is a difficult legal question, but we are so fortunate that we already have an authoritative statement by the UN Human Rights Committee from last year in a claim brought by members of the Torres Strait Islanders. That's an indigenous community belonging to Australia. It was a claim against Australia, where the UN Human Rights Committee found that, or confirmed for the first time ever, that human rights or the impacts of climate change can amount to a human rights violation. In that case, it was concerning sea level rise on those small islands and the land inundation that follows and the salination of fresh water, amongst other things. And that would amount to a violation of the rights to culture, life, human dignity, and others. So here we have from last year an authoritative statement by a UN human rights treaty body that the impacts of climate change can amount to a violation of human rights. But another and very important, maybe even more important and related question is, what exactly are the corresponding duties of states to prevent the violation of human rights? Duties under human rights law. And answering that question is not yet so straightforward, because here we don't have yet any international court or authoritative judicial statement that is very specific on those duties, other than duty to adapt to climate change, as it was in that Torres Strait Islander case. Now, we do know that states have positive obligations to adopt all necessary and adequate measures to prevent the violation of human rights. It's not just to not kill, not violate, but also to set in place the conditions that are necessary for individuals to fulfill their human rights. What exactly, as I said, what exactly this means is yet to be something that courts may come back to either this year or next year. As I said, there's this groundswell of international courts being faced with these questions. But we face a situation where many of the human rights treaties were adopted right after the Second World War or after, but are silent about environmental, let alone climate change issues. It doesn't feature in the legal texts, which means that, similar to the Earth Charter Treaty, these treaties also have to be interpreted in the context of climate change. What does it mean to have a right to life, right to private life, right to human dignity in our contemporary context, where climate change impacts are already pertinent? So that requires interpretation. Now we know that no international treaty is an island and can be seen in absolute isolation. They all have to be seen in the normative context within which they exist and within which they are being implemented. And that, of course, links to, I don't need to go into the methodological details here, I'm sure you're all aware of that, but this links to the role of the Paris Agreement in the interpretation of these human rights treaties. The Paris Agreement, therefore, because it is the latest and most comprehensive, legally binding international treaty, but it's a separate one, but it plays a role in the normative interpretation of human rights law. It is relevant because it provides normative guidance on the general global direction of addressing climate change, in particular in its objective to hold global warming to well below 2 degrees and taking efforts to keeping it at 1.5 degrees. I'm sure you all have heard about these global goals, which would not exist, although they're so widespread now, even at the level of private corporations which want to be Paris aligned, and we heard about it, but they would not exist without the Paris Agreement, because they're not scientific goals, they're goals that were based on a global consensus that this is where the unity or community of states decided to hold climate change. Keeping these goals requires immediate, rapid, deep emission reductions by about 45% in 2040, and then towards net zero emissions, CO2 emissions at around 2050, at the middle of the century, and net negative emissions thereafter. And I mentioned these numbers, which are all also here in that report that we've seen the beginning here. Yeah, I know exactly what they are. Yeah. But they're not just numbers, because behind those numbers hides the need for a complete transformation of the energy sector. If you break down these numbers, that is what is needed, in addition to many other things. But in addition to that general travel of direction, which then would need to be interpreted in the context of human rights law, the Paris Agreement provides more normative guidance. For example, we already heard that states have the legal obligation to communicate nationally determined contributions, their climate plans, every year. But it's not that this is entirely up for grabs and everything goes. The agreement also sets the normative requirement that these nationally determined contributions have to progress every 5 years, meaning they have to become better and better and better in their level of ambition every time parties communicate them. The next time around is in 2025, which is a very important moment in time to have a good look at that. And they have to reflect each party's highest possible ambition. And that's an important legal parameter. It's reflected in Article 4, paragraph 3 of the agreement, because this can become a very important tool in human rights cases where courts may want to inquire whether parties actually have included in their climate plans their highest possible level of ambition. This is reflective of a due diligence obligation where parties need to put forward their best efforts and can be applied or can be seen as an obligation of conduct to exercise their best efforts. And as I said, under human rights law, that provision could hold a very powerful normative element to inform the human rights requirement of fulfilling positive obligation, taking all necessary and relevant measures. Eventually, we will have to leave this to the courts and we'll see what they will do. But as I say, these issues are pertinent, are pending in many courts worldwide, including the highest court of the world. And the hope is that these courts understand well and use the power of the Paris Agreement in order to require of states the ambition that is necessary in order to fulfill the goals of the Paris Agreement, in particular in light of record-breaking temperatures. As you mentioned, you just have to switch on the TV and see that both in China and in your country, in California, in Spain, in Italy, we have record-breaking temperatures almost on a weekly basis, and we see the wildfires currently spreading in Greece. There is no doubt that this is needed, and it is urgently required by the rule of law, not as activism, but as a legal and professional duty and responsibility of all those that are engaged with the law. Thank you very much.
Thank you so much, Christina, for your very analytical overview of the state of international law, especially international environmental law, international climate law, also linking it to human rights. And if we had some time to discuss, I would like to come back to these cases just being in the Strasbourg court in the Grand Chamber, but let's see. Thank you. And next we have a speaker, my friend from Australia, New South Wales, Brian Preston, who is Chief Judge of the Land and Environmental Court in the New South Wales province. Brian is a prominent figure in environmental law, not only in Australia, but worldwide, one of the best known environmental lawyers in the globe. And prior to his career as chief judge in November 2005. He was a senior counsel practicing primarily in the New South Wales in environmental planning, administrative, and property law. His breathtaking academic merits in environmental litigation and being an author of 144 articles shall be mentioned here. And he's served as visiting professor in the United Kingdom, adjunct professor in Australia, and he has participated very extensively in capacity building and teaching throughout Asia, Africa, and the European Union. And Brian is going to tell us something about climate litigation from the point of view of government accountability. Please, the floor is yours.
So tackling the existential crisis of climate change requires ambitious action by governments to reduce greenhouse gas emissions from human activity. As Christina Voigt said, the goal is to achieve net zero emissions, a balance between anthropogenic emissions by sources and removal by sinks. So the emission reductions need to be deep and rapid in order to limit global warming to the agreed temperature target of well below 2 degrees above pre-industrial levels by the time target of the second half of this century, so 2050. The government of a polity needs to take the lead in setting and implementing the strategic policy and legal frameworks needed for effective climate action. As our chair, Kari said, the three arms of government each play a role. The legislature needs to enact the relevant laws. The executive needs to execute these laws and implement policies and take the relevant climate action. And the judiciary needs to hold both the legislature and the executive accountable for discharging their responsibilities. In this presentation, I want to focus only on the executive branch of government. So the executive government may breach the law in, I'm going to say, 7 ways, which I'll group. And the judiciary can hold the executive accountable for these breaches of law. In my 7 categories, I will have 5 dealing with policy and 2 dealing with action. My first category is a failure to adopt a climate policy. So legislation may require the executive government to adopt policies to mitigate or to adapt to climate change, and the government may fail to do so. In a case in Australia that I actually presided over, the Land Environment Court held that the Environment Protection Authority had failed to perform its statutory duty to develop environmental quality objectives, guidelines, and policies to ensure the protection of the environment from climate change. And the court ordered the government to prepare those policies. The government subsequently has prepared those policies, and they were released in January of this year. A second way is that the executive government may adopt a statutory rule, but do so other than in accordance with law. And the example I'll give is the United States case of West Virginia and the Environmental Protection Agency. There, the US Supreme Court held that Section 111D of the Clean Air Act did not authorize the US Environmental Protection Agency to regulate carbon dioxide emissions from existing coal-fired and natural gas-fired power plants using the generation shifting approach that it had adopted in the Clean Power Plan rule. My third category is that the government may adopt a policy, but that policy is contrary to law. The example I give is an Irish case, the Friends of Irish Environment against Ireland. There, the Irish Supreme Court held that the Irish government's national mitigation plan, a type of policy, which sought to transition Ireland to a low-carbon economy by 2050, fell short of the specificity that was required by Ireland's Climate Action and Low Carbon Development Act. It said that a reasonable reader of the plan could not understand how Ireland would achieve its 2050 goals, and that was contrary to law. My next category is that a policy may be adopted by the executive government, but the executive government doesn't implement it. My example is the Lavrysen case against the Federation of Pakistan, the Lahore High Court case, where the Lahore High Court held that the Pakistan government's inaction in implementing its policies that it adopted for adaptation to climate change breached Mr. Lavrysen's fundamental rights, and it ordered that the government implement those policies. The government might adopt a policy according to law, and it may take some action, but the action is insufficient. And an example comes from India, Gareth Kumar Bonsoy, where against the Union of India, where the National Green Tribunal ordered the state governments, in that case, to implement the National Action Plan on Climate Change. And then we might have the executive government might adopt a climate policy or take climate action, such as setting and implementing the level and rate of greenhouse gas emission reductions, but that in itself breaches the law. And my example is the well-known case of the Agenda Foundation against the state of Netherlands. There, at the three levels of courts, they found that there was a breach of law in the government's action. At first instance, it was a breach of the duty of care under the Dutch Civil Code in hazardous negligence, and in the Court of Appeal and the Supreme Court level, it was a breach of the European Convention on Human Rights. There are my five categories on policy, 2 to go, this time about climate action more generally. And so the executive government may fail to take adequate climate action, and in so failing, they may breach the law. My example is a French case, Notre Affaire Atout, against France. The Ministry of Court in Paris held that France was responsible for failing to meet its climate and carbon budget goals under EU and national law, and that was in breach of various laws, both nationally and European law. My next case about failing to take adequate climate action is one that Professor Voigt referred to, the UN Human Rights Committee for the Torres Strait 8 people who brought an action against the state of Australia. And the committee found that the Australian government's inaction violated the right to be free from arbitrary interference with privacy, family and home, and the right to culture. The minority found that it was also a breach of the right to life. The majority said it wasn't yet a breach of the right to life, but said on current trajectory, if the Australian government doesn't take any action, it will be a breach of action. Of course, the Human Rights Committee can't make a formal order, but it can make a request, and it requested that the Australian government take action to more effectively mitigate the emissions from Australia, but more importantly for the Torres Strait Islander people, take adaptive action in order to stop their homes being inundated by rising sea levels and other impacts on their life and culture. My final category then is there may be a duty under law to take climate action, and the government has breached that. We've had some litigation in Australia where it was alleged that there was a statutory duty under the environmental legislation to exercise powers in such a way as to prevent climate action or cause climate damage. At first instance, that was successful. On appeal, it was unsuccessful. That's the Sharma case. But there is another case pending, again by Torres Strait Island people, Pabai and Kabai, against the Australian government, where they are alleging on other grounds that there is a breach of the duty of care towards those people. So I conclude by saying, by performing its essential role in holding governments to account, the judiciary upholds the law and the rule of law. Now, where the law promotes taking action to reduce greenhouse gas emissions by sources and to increase removal of greenhouse gases by sinks, the judiciary's actions facilitate the achievement of effective climate action. Thank you.
Thank you very much, Brian. It was a fantastic analysis of different ways to fail in protecting the climate by the executive branch. And I would like to point out that who is then the one who saves the climate? It's of course the courts. The cavalry rides there and saves the climate when the courts are independent. Courts are safeguarding the rule of law, including that of protecting the climate. Thank you. Talking about failures, so as a chair of this panel, I have failed to keep up with the timetable, but still I would say that we were able to start a little bit later than expected, as they say in air traffic, due to the late income of the plane. But we still have one presentation. And is it so that we cannot have the video of Lavrysen? No. In that case, I must just apologize, but luckily I do have his presentation or outline of his presentation, which I have now the honor to read to you. Lavrysen is a professor, doctor, president of the Belgian Constitutional Court. He's the president of EU Forum of Judges for the Environment and the member of the board of the Global Judicial Institute on the Environment. He's also involved in UNEP's judicial program already since 2002 and in the task force on access to justice of the UNESCO Aarhus Convention, in which he is the chair of the current intersessional period. And his presentation is on constitutional issues, separation of powers, and the rule of law. He regrets that he cannot be with you in person due to the Belgian National Day tomorrow, and he shall attend in person because of his function as the president. Climate policies and laws have from time to time a huge impact on polluters or consumers. Therefore, it's not surprising that those affected by those policies are also from time to time complaining that their constitutional rights are violated, be it the freedom of enterprise, protection of property, equality before the law, and non-discrimination, or basic legal principles as legal certainty, legality, and proportionality of criminal offenses and penalties, and so on. The case law of the Belgian Constitutional Court may illustrate this. They have judged over time around 15 cases dealing with climate change legislation. For example, the court found in a judgment in 2006 dealing with the emission trading scheme of EU no discrimination of steel companies compared with the non-ferrous and chemical industries. the court ruled that in the first commitment period of the EU scheme, it was justified to start applying the system to the largest emitters first. Climate change policies justify limitations on freedom of enterprise and property rights. The court held in judgment the same year that the development of offshore wind energy justifies higher government support than land-based wind farming because of the extra cost for this type of renewable electricity production. After the court had referred the case for a preliminary ruling to the CJEU, it held in a judgment of December 2010 that the obligation to blend a growing percentage of biofuels into fuels for cars entailed no violation on the freedom of religion, various EU directives, the freedom of enterprise, nor of the free movement of goods. In two judgments of last year and this year, the court held that the restriction on property rights and the freedom of enterprise due to regional legislation phasing out fossil heating was justified and proportionate in light of the greenhouse gas reduction targets and the Paris Agreement, the EU burden sharing regulation. Climate litigation, and in particular strategic climate litigation in which citizens and NGOs are requesting for more ambitious climate action, is on the rise worldwide. Often in those cases, an argument of separation of powers is invoked to decline the action. Indeed, the separation of powers is a strong pillar of the rule of law, but its precise understanding varies between various legal systems and jurisdictions. The argument was all the time present in the well-known Urgenda case, also referred by Chief Justice Preston. The state of the Netherlands argued in the first instance, in appeal and in cassation, that it was up to the legislature and the executive to determine how ambitious its climate policy should be, and by accepting the claim and imposing more mitigation efforts from the state of the Netherlands, the judiciary would in fact take the place of the legislature and the executive, and thus violate the fundamental principle of the separation of powers and undermine representative democracy. It was finally up to the Supreme Court to say a last word on this issue. Based on the very detailed conclusions of two advocates general of the court, it dismissed the cassation appeal in a judgment in 2019. The Supreme Court based a judgment on the United Nations Framework Convention on Climate Change and on the state's legal obligations to protect life and well-being of citizens in the Netherlands, enshrined in the European Convention on Human Rights. According to the court, there is a broad consensus between science and the international community on the urgent need for developed countries to reduce greenhouse gas emissions by at least 25% towards the end of 2020. The state has not explained why a smaller reduction can be considered justified and may still achieve the ultimate objective accepted by the state. The state had defended the thesis that decision-making on the reduction of greenhouse gases belongs to policymakers. However, the court observes that the Constitution obliges the Dutch judge to apply the provisions of the European Convention of Human Rights. The judge's task of providing legal protection is an essential element of the democratic rule of law. This is what the Court of Appeal did in this case, according to the Dutch Supreme Court. By imposing a global reduction target without prescribing concrete measures to reach that objective, it is argued that there's no breach of the principle of separation of powers. The legislator and executive remain competent to work out the concrete policy mix of instruments to reach that goal, enjoying a large margin of appreciation in doing so. The decision contrasts with the decision of the Federal Supreme Court of Switzerland in the Klimasenioren case, in which the court held that deciding on the climate change policy ambition was a matter reserved to the parliament and the government. And now we know that this case is in the European Court of Human Rights in the Grand Chamber in the coming autumn. Germany illustrates that the constitution can also be of great importance from another point of view. In February 2020, a group of young German people filed a legal challenge before the Federal Constitutional Court to Germany's Federal Climate Protection Act, arguing that the target of reducing greenhouse gases 55% by 2030 from 1990 levels was insufficient. The complainants alleged that the act therefore violated their human rights as protected by the basic law, Germany's constitution. April 2021, Bundesverfassungsgericht in Neubauer et al. Case struck down parts of the Climate Act as incompatible with fundamental rights for failing to set sufficient provisions for emission cuts beyond 2030. The court found that Article 20A of the Federal Constitution obliges the legislature to protect the climate and aim at achieving climate neutrality. The court stated that Article 20A is a justiciable legal norm that is intended to bind the political process in favor of ecological concerns, also with a view to the future generations that are particularly affected. Accepting arguments that the legislature must follow a carbon budget approach to limit warming to well below 2 degrees and if possible to 1.5 degrees, the court found that the legislature had not proportionally distributed the budget between the current and the future generations, writing, one generation must not be allowed to consume large parts of the CO2 budget under a comparatively mild reduction burden if this would at the same time leave future generations with a radical reduction burden and expose their lives to serious losses of freedom. The court ordered the legislature to set clear provisions for reduction targets from 2031 onward by the end of 2022, which has, by the way, happened. Following that ruling and with a view of the new European climate target for 2030, the German federal government presented an amended Climate Change Act. Following the reasoning of the German Constitutional Court and in light of the most recent UNEP GAP reports, it might be expected that the constitutional dimension of climate change policy will only be more and more on the forefront in the decades to come. With this, Professor Lavrysen wants to conclude his presentation and thanks you for the attention and wishing us fruitful discussions. Thank you. So, given the time, there's no time for discussion, which I truly apologize. But we had a great discussion in the panel, and I sincerely hope that you have enjoyed the extraordinarily fantastic speakers of our panel, which I would like once again to give our heartily thanks.
you.